Good afternoon, everyone. Welcome to Grant Thornton and IACC webinar on one of the most significant reforms since GSC, the implementation of the four landmark labor codes notified with effect from 21st November 2025. Today, we would like to deliberate on key impact areas, discuss some practical insights relevant for both the employers and employees. To set up the context, as everyone know that there are 29 existing labor laws which have been repealed and subsumed with four new labor codes, that is the Code on Wages, uh, Industrial Relations Code, the Code on Social Security, and the Occupational Safety, Health and Working Conditions Code. With this context, I am now inviting Dr. Lalit Bhasin, who is an advocate and the founder of Bhasin and Company Advocates. He is globally respected leader in corporate laws and arbitration. He has served as a past uh, president of the Indian-American Chamber of Commerce and Bar Association of India and chairman emeritus of CI Arbitration India. His contributions have been honored with multiple national and international awards, including Lifetime Achievement Recognition and honorary doctorates. Along with him, we have Ashish Mohan Vig, who has decades of leadership experience in India's construction and infrastructure sector. He currently serves as a member of the Central Board of Trustees, EPFO. Mr. Vig is also the chairman of the Infrastructure Committee, Indian American Chamber of Commerce, Northern Region. I would like both of you to share your point of view on the critical factors that have been instrumental in facilitating the national-wide implementation of the labor codes. Over to you, sir.
Over to whom? Which one?
To you, sir.
To me, okay.
Give your point of view on the overall on behalf of Indian American Chamber.
Yeah. So it's a privilege for me to participate in this webinar, very well organized by Grant Thornton and Indo-American Chamber of Commerce. And my thanks to Mr. Ashish Vig and Mr. Akhil Chandana for jointly putting in place not only this webinar on the discussions relating to four codes, but also to get the presence of our esteemed Secretary, Ministry of Labour and Employment, Mrs. Vandana Gurnani, and Dr. Mahendra Kumar, Joint Secretary in the Ministry of Labour and Employment, because their presence is very relevant, keeping in view the fact that there are certain ambiguities which are being faced by the legal professionals, that is, the lawyers like me who have put in 63 years of law practice, out of that, most of the time on the labor laws, and also the general counsel, the in house counsel, whose responsibility is to implement, you see, the labor codes in their respective establishments. You see, the relevance is that there is an uncertainty whether the codes have become operational or not, because in all the labor codes there are frequent references in various sections of the codes to the expression as may be prescribed. As may be prescribed, you see, this occurs at so many places. That means things have to be prescribed under the rules, and unfortunately the rules have not yet been finalized and put into operation. Therefore, in the absence of the rules being put in place, and the 1st April has also expired now, have the codes come into force, or still we are awaiting the finalization and notification of the rules which have to be put in place? And then what is the relationship, you see, between the central government and the state governments, because it is a concurrent subject, and the states also have the empowerment under the constitution, schedule 7, you see, to bring in their own respective laws, and some states have already done so. I can understand that so far as service conditions are concerned, there could be uniformity, you see, all over the country to some extent. But so far as the working conditions are concerned, those have to be decided and put in place keeping in view the old principles laid down by the Supreme Court of India, region come industry. These will be the consideration for the states, particularly in the field of fixing the minimum wages, fixing the working hours, other working conditions. You see, what facilities to be given, that would come under the jurisdiction of the states. And also, what will be the status of the Shops and Establishments Act of the different states, which set out, these working conditions, in the states. Therefore, this role of the states and the center, to what extent you see that would meet the requirements under the new labor codes. This is something on which some enlightenment is required, particularly from the government. And since we have the esteemed presence of Mrs. Vandana Gurnani and Dr. Mahendra Kumar representing the government, we should get some clarification whether the codes have come into force in the absence of rules being in place. If so, then what is the extent to which one has to comply with those codes? You see, these are very fundamental, basic questions which ought to be answered. So I'm grateful that you have given me this opportunity to express my views. Now I hand it over back to you, Akhilji.
Thanks, Dr. Vasi. Mr. Ashish, I will come back to you as ma'am has already joined. And in interest of the time, and you've seen the excitement. A lot of people are giving a thumbs up and expecting a lot from the ma'am. So, ma'am, we are honored to have you today with us and joining us as our chief guest. Just to give a background about ma'am. Ma'am has been involved with the ministry in various capacities during her career spanning over 3 decades. She was instrumental in framing the labor codes and has deep insights into all aspects of its implementation. Along with her, we have our chief, guest of honor, Dr. Mahendra Kumar, Joint Secretary, Ministry of Labour and Employment, Government of India. People are very much excited to see you here. You can see that the thumbs ups, the hearts people are sending, and the excitement they're showing. Along with and Dr. Mahendra Kumar will stay with us till the end. Do Madam has a time limitation, 10-15 minutes, but Dr. Mahendra Kumar will stay with us. We've also honored to have on our panel Ms. Sunita, Senior VP and Head of HR Quest Corporation Limited. Last but not the least, my very own colleague and partner at GT from Global People Solution, Rashri Sarna. So, ma'am, before we call anyone, we want you to express or enlighten our audience on the overall scheme of things, specifically on the roadmap ahead. As Dr. Lalit Bhasin also said that many employers are still awaiting clarity on the transition roadmap under the labor codes, particularly on when central and state rules are expected, as compliances are presently being followed under the subsumed laws. Interpretation and workforce issues. I think there's some ambiguity around interpretation issues such as the core business test for engagement or contract labor, basic for wage linked, base for wage linked entitlements like overtime, leave encashment, maternity benefits. Also, the classification of worker into worker versus employees and managerial or supervisory role. And the last basket, which we want you to touch upon, is overlap with the other laws. As you know, finally, clarity would be very helpful on how employers should navigate the interplay of labor codes with the state shops and establishment acts, which are also not subsumed under the labor codes. Also, when would be able to see alignment with other legislations such as income tax laws. As you know that income tax laws on the perquisite or other benefit are talking differently, and here it's a different interpretation. Over to you, ma'am.
Thank you, Akhil. So at the outset, I'd like to thank the Indo-American Chamber of Commerce for organizing this webinar and for creating this kind of a platform, which is very important for constructive engagement and dialogue as we move forward on the implementation of the labor codes. I'd also like to mention that from the ministry, from day one, we have been constantly engaging with the industry representatives, with the industry bodies of all kinds, including not just CIFAK, but also the MSME associations. And other such organizations, so that whatever questions and doubts are, they are clarified. And let me also mention that these engagements have not been limited to only New Delhi or the national capital. We have actually gone out into regions. We've had 5 regional workshops in 5 regions of the country, where we have invited local industry representatives from that particular state where we had it, and from the neighboring states who were invited to these regional workshops to have more detailed engagement with them, because we do recognize that India is a large country and there may be different kinds of requirements in different regions. So we have even taken care to make sure that we have regional dialogues, not just with the states and UTs, but also with the industry. So this is the paradigm we work in, and we are glad that you organized this discussion. And though I'll be here for a brief while, my team is here fully ready to engage with you and answer any of your questions. So in terms of, I think, background, I hope you all recognize, and many of you have been part of this journey of even crafting the labor codes when they were drafted. There were several engagements. There have been more than 100 plus engagements that have been done by this ministry with various stakeholders, notably the industry bodies, also with the states and UTs, with the trade unions, with experts, with economists. So it's been a long journey, and finally, we have seen the result of that journey by the decision of the government to make these codes effective from 21st of November last year. And as you would know that with the technological changes that the country is going through, with the changes in the nature of employment that our country is witnessing, with the new forms of employment that have come up in the country, it was imperative that the labor laws are also in sync with that, and that is what these codes attempt to do. The previous 29 laws that we had were actually, many of them dated the pre-independence period, and therefore they were not really fit for the current economic situation that the country is witnessing, or the growth and the changes in employment that we are witnessing. So what the courts have attempted to do is that they have tried to make it fit for purpose. Earlier codes had several definitions which were varying across the codes. There was complete non-uniformity. There was lack of transparency and predictability. And this is what these codes have tried to correct for, to make it absolutely clear and transparent, and also IT enabled. There were also lack of clarity which led to unnecessary litigations, and what we hope is that these codes will lead to reduction in litigations through the transparent mechanisms that it will put in place. I would also like to mention here, because one question came up as to what is the current status. So if you would all know by now that on 30th of December, the rules under the 4 codes, which is on the central domain, the rules will be published. And after that, sufficient time was given, 30 days for code on wages and 45 days for all the other 3 codes to provide their comments. And we have got a huge, I would say, deluge of comments from stakeholders for all these 4 codes. And let me assure you that from the ministry and my team here, each of those comments have been gone through and have been taken into consideration. Every single line, every single word of the comments that have come have been gone through, and the process of the final publication of rules is in the advanced stages, and that should happen in some time. As far as the states and union territories are concerned, because we also recognize that the central government rules are largely applicable in the central domain, whereas a lot of business interaction is with the states, which is why we did the regional workshops with the states, where we have, sat down with the states, seen the rules that they had drafted, provided them technical guidance wherever they needed, and tried to bring the rules of the states also in sync with the overall intent and thinking of the labor codes, while there is room for different states to adapt the rules to their local context. But on major things, there is uniformity that is being ensured through this discussion and this iterative process with the states. I'm happy to tell you that 2 states, that is Gujarat and Haryana, have already finalized their rules. Almost about 13 states have pre-published the balance rules, and rest are in the process of pre-publishing their rules, and they will be finalized shortly. Again, to ensure that during this transition period, there is no lack of clarity, and I'm again mentioning this, there are about a little over 1/3 of the sections in these codes which do not require rules. I hope I'm audible because I see
Yeah, very much.
Dr.
Yes.
Lalit finding, I hope I'm audible, Dr. Lalit.
I wanted to be more attentive.
Okay, I give you a now. Okay. So, uh, in terms of the interim, so more than 1/3 sections of the rules of the Act, that is the 4 codes, those sections do not require rules, and those have come into being already. They are effective from 21st November. So hopefully this answers the question which is most asked by the industry, which is on the definition of wage. So definition of wage has already come into being, and therefore, whatever impact it has on the social security or gratuity, etc., has come into effect from 21st. The balance sections require rules, which I mentioned, would be notified. The final rules will be notified shortly in central domain and then by the states. But in the interim, as per the General Clauses Act and the laws of the land, the rules under the previous acts will govern as long as they're not in conflict with the new codes. So this is as far as the legal landscape is concerned, so that there is no confusion on that. I would also like to mention, if you look at the codes, see, I have come in as secretary when the codes were drafted, and I have gone through the codes and the rules very, very carefully. And my assessment after doing that is that these are a very, very fine balance between allowing the industry to not just survive but to thrive and grow, and also ensuring that the workers get proper welfare, get proper wages, get proper social security. So the codes are making a balance. So the intent of the government through the codes has been that they should facilitate economic growth through allowing the industry to grow. But at the same time, it is not government's intent to shortchange the worker. Government, in fact, wants enhanced benefits for the workers, enhanced wages and social security, welfare, occupational health and safety for the workers. So I think that paradigm I want to clarify, that your cost of compliance and the compliance burden goes down substantively, but at the same time, workers get more benefits. So that is how these codes have been made to strike that kind of a balance. Coming to certain specific provisions of the code. So A, as I said, uniform definition. Earlier, the basic thing like wage, employer, employee, worker, workman, these kind of things varied across the 29 laws. Now there are uniform definitions across all the 4 codes. In terms of benefits to the industry, the compliances, as I mentioned, there is a single registration instead of 4 registrations in the past, 4 or 8.
Registration was
4 or 8. 8 registrations in the past. Licenses have been reduced to 1 from 4 licenses. I got mixed up with the 2. Returns have been hugely simplified from 31 to 8 to 1 return. Your registers have been reduced from some 80 plus to 8 registers. So this is a huge amount of compliance reduction that happens. And all these will be through an IT system. As far as the central domain is concerned, our IT system for this is ready. When the rules are launched, this IT system will also be launched simultaneously. So
ma'am,
that is
just what you were saying, I think it's coming in the slide also. The kind of convenience and everything brought in
Yes.
by the ministry.
Yes. Okay. Thank you for putting up on that slide. Then the other important thing is that decriminalization of offenses. We had about 87 different provisions which attracted a criminal liability on the establishments and the industry. Now those have been reduced to 22. And in this 22 also 16 offenses are compoundable. where it can be converted into a penalty, and 6 are the only ones which are non-compoundable. And which are these 6? These are the ones which are absolutely serious ones. So in case there is a violation of safety standards, occupational safety and health standards, because of which workers are losing their life or limb. You must have read about this incident in Chhattisgarh recently. Now, why in today's days, after so many years of independence, why should we have such incidents happening in our country where workers have to lose their life because of occupational safety reasons? This is something which is still criminalized, rest has been decriminalized. Now, collecting social security contributions and not depositing into the social security fund in the organizations, that is still a criminal offense. Apart from that, all other offenses have been decriminalized. Now, I said this actually places a huge onus on the industry to be self-compliant. And I would in fact urge the chambers of commerce and this Indo-American Chamber of Commerce to actually think of having a competition among industries. Which are the ones which are following all the occupational health and safety standards? Which are the ones which are looking after all the labor related welfare measures? I think that's the direction in which we really need to move towards. Then I will talk about, when I talked about transparency. Now, everybody has to have an appointment letter, including the contractual workers. We all know that while regular workers get taken care of, it is normally the workers who are on contract who get lesser benefits, or are, I would say, to use a stronger word, they get shortchanged, even though they do similar work as regular employees. So we have to make sure that everybody gets an appointment letter. And this is also to the benefit of the employer because it creates transparency. Because currently a lot of litigations happen because of lack of transparency of actually the terms and conditions of a worker. So this, by making it clear through an appointment letter, we hope that there will be less of confusion and lesser litigation. Similarly, minimum wages which were earlier restricted to only scheduled employments, these have been made universal across the country. So every single employment, every type of occupation has to get minimum wages. Social security coverage has been expanded to cover unorganized workers, to cover gig and platform workers. And if you look at social security, the ESIC coverage will now be pan-India. The ESIC is offered as a voluntary coverage to establishments which want to opt for it, including the ones less than 10. For mines, it has been made mandatory. For plantation workers also now, ESIC coverage will be available. So I think, as I said, the thrust of the government is that more and more welfare for the workers. One of the big things for the industry is higher thresholds. So whether it comes to taking a factory license, there are higher thresholds. Contract labor license, there are higher thresholds. So all these have been done to make sure that the industry is able to grow. Fixed term employment was a long standing demand of the industry. Now, fixed term employment has been made possible through the labor codes. You can engage people for a particular duration in case it is a seasonal demand, in case certain expert services are needed. You know better than us in what situations you can take fixed term employment. You can take them directly without going through the contractor. The contractor fees is also saved in that process. So that's also been accommodated in the codes. So overall, I would say it is simplifying compliance, promoting ease of doing business, and promoting worker welfare. And I'd like to just put this, worker welfare, whether it's social security or it is a safe environment, better health facilities, and better checkups, annual health checkups, etc. I would actually like to also view it in the light of productivity. As you know, India is one of the countries with a low productivity. And today morning, I was having a discussion with an organization which works on workers' safety. They in fact have done a research that there is a direct link between the safety and the occupational health and safety measures in the workplace and the worker productivity, which is something I thought was a great research, because in my mind I used to think productivity is probably only linked to skills or linked to intergenerational nutrition issues, etc. But what has been borne by this research is that the better safe environment that we provide to our workers, the higher is their productivity, which is in the interest of the industry. So just wanted to highlight this to you so that the the enhanced welfare, enhanced social security or wages that you have to provide would also lead to more, say, more healthy, more satisfied workers who will be contributing to productive establishments and would be, I would say, more bound and loyal to the establishments. Then I think there was this issue about the core and non-core activities. Our take is actually the codes bring a lot of clarity on what is core and what is non-core. If you look at the previous paradigm, there was a board which was deciding what is core or non-core. So there was an element of discretion in deciding what is core or non-core. What the code does is it removes that discretion completely. It defines what is core, it defines several things which are non-core, and it also defines which are the which are the kind of activities where even if it is core, the establishments can still take on contractual work. So that's very, very clearly established in the code, and I'm a little surprised why this question keeps coming again and again, because many of you have very good legal teams with you, and if it is read carefully, the code on this part is absolutely clear. So this is something I just wanted to mention about it. The other thing I think which bothers industry is the inspections, and as you know, in the central domain, we have already moved to risk-based inspection systems, and many states have also moved to that. So this is also being done through an IT system. So what we have done is that we have worked on an inspection scheme where we have developed algorithms for identifying risks. Now the risks may be different for ESIC or EPFO or our Central Labour Commissioner, but we have identified a series of risks so that our IT system is able to, with the help of those risks, identify the establishments which need priority inspections so that 100% of the establishments are not in the inspection fold. But as I said, this places even more onus on the industry to make sure that you are fully compliant. And to help you, we have even brought out a compliance handbook, which we have put in our website, which tries to demystify the legal language. And this was something I was very keen on doing because our MSMEs, many of them are not in a position to hire expert help to interpret the laws for them. So we have tried to remove the complicated legal language and give out a very simple, compliance handbook, which is on our website, which any new startup, any new establishment, new industry coming up, an MSME can go through without requiring the, plethora of expert services that they need to hire or pay for. So this is something I would like to, again mention and highlight. The inspection system, therefore, will bring down human discretion and provide a lot of transparency. Our digital systems, Shamsuddha and Samadhan portals, they have been revamped to make them adaptive to the new codes. We have also offered to the states that you can use this platform if you are not in a position to develop it on your own. You can use the national platform, and their requirements have been factored into this new IT system. The other issue you mentioned was the Shops and Establishments Act. Now, when it comes to the Shops and Establishments Act, we are aware of the kind of possible overlap between the Occupational Safety Health Code and the Shops and Establishment Act. So what we have done in the ministry is we have done a very detailed exercise, as part of which we have pointed out to the states that there are provisions similar in the Occupational Safety Health Code to the Shops and Establishment Act. And we have also pointed out a few provisions which are not there in Occupational Safety Health Code, which are very specific to the state. For example, declaring local holidays in sync with the local festivals. Now that cannot be done in a national act like the Occupational Safety and Health Code. So these are a few things which states for which they need the Shops and Establishments Act. So we have presented this to the states, and states are actually going through this, and they are working on how they can synchronize both these codes. One of the simplest thing is to do common registration. So we are willing to accept if somebody is already registered in shops and establishment, that can be taken as automatically registered in OSH and vice versa. It needs integration of the IT system. So that is something that can easily be taken care of. And these other smaller issues which are absolutely local in context, like the holidays, like opening and closing time of shops and establishment, 24/7 working of certain establishments. So these are things which we have pointed out to the states that please look at this and see how you would synchronize and how you would align both these acts. And they are actively examining those. And I'm sure that states will soon be able to find solutions to this. And we are constantly in touch with them for the same. Also wanted to mention that many of the questions that you have on wage, gratuity, variable pay, ESOPs, etc., we have through FAQs tried to clarify them and put it up on our website. We have gone through all your suggestions which have come to the rules. I would just like to mention one thing, that many of these suggestions are pertaining to the code. So I think I need to explain this here, that code is passed by the parliament, it is the law of the land. It cannot be changed through rules. Rules are more in the nature of defining the processes, defining the forms, annexures, etc., in which you need to, apply for something. So the code cannot be changed to the rule. So I think that clarity is extremely important. The other suggestions which have come, we have very, very carefully, examined those suggestions which have come on the rules. I would also like to, mention one more thing, that while the team is here to answer any further questions, I feel that, since this is Indo-American Chamber, you would also know that if these codes are well implemented, it will give a big boost to the exports of the country. Because one of the important things which the exporters go through is certification and audit of their compliances on the labor laws. And these labor laws are very forward looking in terms of the welfare of the workers. And if these are adopted well, it would help the exporters to get those compliance certificates and be able to give a big boost to our country's exports. This is something I really wanted to point out. And therefore, I would urge that now the time has come for us as a country and for all of you, and I appeal to you that let's try to become model employers. Make sure that we give appointment letters. Make sure the contractors give appointment letters. Everybody is covered in social security, not just the regular, but the contractual employees. If you're hiring contractual employees, you can insist with the contractors to make sure that they get the social security coverage. Wages are paid on time. You are seeing what is happening across the country right now. So many agitations. I mean, if we don't get our salaries on time, it is difficult even for us to survive. How can a worker who is getting a minimum wage survive if the wages are not given on time? So I'd urge that as an industry, giving decent wages, giving timely wages, providing overtime when they have worked beyond the stated hours, which is defined in the law. I think the onus is on us to make sure that these are complied with, and there are absolutely no kind of violations in this, because government is placing a lot of interest, a lot of I would say faith on the industry by bringing in such proactive measures. The onus is now on the industry to make sure that these are complied with, these are followed with, and all our workers are satisfied, happy, and healthy and productive. And at the end of this, when we see this transformation, I would like to send the hearts to you as you were sending to us in the beginning. Thank you so much.
Thank you very much, ma'am. I think the last 25 minutes, the way you've taken down each and every angle, and the passion which you and your team has shown while we cover this journey, because
I
we
would
have
just
been
add very, very elaborate, very informative, very educative. You see this, which has come from the Vardi Secretary, Ministry of Labor. We are very grateful to you for the clarification that you have given. and these will go a long way in getting implementation of the codes. You see, particularly when you said that the codes are in place, therefore, even if there are no rules which may be connectable to the provisions of the code, those have to be implemented forthwith. I think that's a very informative uh, subject. Thank you very much. Thanks a lot.
Thank you, ma'am. Thanks for taking your
Thank
time
you
out.
so much for organizing this. Our team is here to interact with you. Thank you.
Yeah. We take it forward from there. Thank you. So I'll ask Ms. Ashish to come in and share his perspective. I know he was to start the session after Dr. Lalit Bhasin, but our chief guest was here, and because of the limitation of time, we wanted her to come. Ms. Ashish, your point of view before we start the panel discussion with Dr. Mahendra Kumar, Rashi Sarna, and our client Sunita.
Thank you, Akhil. Thank you so much. Dr. Mahendra Gupta ji, his team, Dr. Lalit Bhasin, very honorable president over the past many years, and we really look up to him for his guidance. All the other members in the panel, and of course, people who have joined in. I would start by saying that as we are moving towards Viksit Bharat in Amrit Kal, positive steps are very important by the government to guide the industry in the right direction, to give the right push to the industry in the right direction. Of course, it goes without saying that we at IACC do welcome all the initiatives of the government and these 4 labor codes. But जैसे कहते हैं opportunities के साथ साथ challenges भी आते हैं. तो opportunities तो हैं, दिखती हैं, सामने नज़र आती हैं और we are excited about the opportunities like ma'am just mentioned. We should be a role model. We should take advantage as far as the IACC is concerned, guiding our members. I will not really go into all the positives because most of us have seen the positives. पर जहाँ पर डॉक्टर महेंद्र गुप्ता जी की गाइडेंस या इनपुट हमें चाहिए होगा, एक चीज़ मुझे ऐसा लगता है कि जब ये कोड्स बनाए गए तो इनको जब हम पढ़ते हैं तो ऐसा लगता है ये लार्ज कॉरपोरेट्स के लिए ज़्यादा है. जो हमारे मेंबर्स भी एमएसएमई सेक्टर है, वो शायद ये कोड्स को उतना क्लोजली फॉलो नहीं कर पाए, और जब क्लोजली फॉलो नहीं कर पाएंगे तो सामने पेनल्टीज और क्रिमिनल प्रोसिक्यूशन आ जाते हैं. और इसमें आईआर में ख़ास तौर से काफ़ी सख्त क्रिमिनल प्रोसिक्यूशन दिखाए गए हैं. मेरा ये मानना है, मेरा ये कहना है कि अगर हम हैंड होल्डिंग हमें गवर्नमेंट कर दे फॉर a couple of months or maybe some set duration of time, it will take the industry much positively forward. वो डर जो हमेशा लगा रहता है कि मैंने ये कंप्लाई नहीं किया, मैंने वर्कर को निकाल दिया तो मुझे ये कागज बनाने थे, you know, all these things do create a problem for the employer. Yes, there is no discussion that the employee benefit has not to be given. It has to be given. It has to be paid to the fullest. The social security has to be taken care of.
So we are not able to hear you. We've lost your voice. Ashish ji, we're not able to hear you.
म्यूट कर दो.
Ashish ji. आशीष जी, वी नॉट एबल टू हियर यू. आपकी आवाज नहीं आ रही हमारे पास. I think there's some network problem with him. It's well the thoughts of Ashish ji. Ashish ji, you're back. We're not able to hear you. Are we audible?
Yes, you are audible.
We're losing you. I think some network problem at your end.
नेटवर्क तो पूरा आ रहा है, 5G दिखा रहा है और 4 डंडे भी दिखा रहा है.
Now it's better. Now it's better, sir. Now it's better. You can continue. In between, we've lost you.
डोंट नो कहाँ तक आपने सुना था, मुझे पता नहीं है, बट आई विल जस्ट से अगेन दैट आई विल नॉट गो इनटू द pluses of the opportunities of the codes. I would like to highlight as an industry, the industry viewpoint, that I feel that the codes are probably made keeping in mind, by and large, the big corporates, because the type of record, the type of IT enabled system, the type of compliances are to be done. This may be a challenge for the MSME sector. Number one. Number two, I feel that relying so much on IT may create a digital divide, because the corporates, establishments who are not that tech savvy, they may land into a problem. Considering these things, I feel hand holding is important from the government side for the industry, at least for some set period of time. There should not be a डर, एक डर नहीं होना चाहिए कि मैंने अगर ये अपना रजिस्टर कंप्यूटर पे नहीं डाला या टेक्नोलॉजी के हिसाब से मैं नहीं चला तो मेरे ऊपर फाइन लग जाएगा, पेनल्टी हो जाएगी, क्रिमिनलाइजेशन हो जाएगी, जो कि IR कोड में है लिखा हुआ, कई जगह लिखा हुआ है. Another thing I think we should mention, we should talk about, and Mahendra ji would explain, is quick dispute resolution must be there in all the 4 codes. Probably I have not been able to see it in all the 4 codes. And like everybody has been talking again and again, the uniformity of definition is not there. That is also very important. And of course, ये आप लोगों ने भी देखा होगा कि जो डेफिनेशन ऑफ एस्टेब्लिशमेंट है वो भी चेंज हो जाता है. OSH कोड में कुछ कह देता है, IR में कुछ कह देता है. तो जब एक एम्प्लॉयर है उसको पता नहीं कि मैं एस्टेब्लिशमेंट किस में आ रहा हूँ, तो फिर दिक्कत हो जाती है. I think that is where IACC would love to, be with the Ministry of Labour, and like we all were discussing, maybe through a webinar, we will again ask Dr. Mahendra ji to be guiding us in our different endeavors in the different webinars. So this was just a very, very brief. I thought I'll mention the challenges. Of course, opportunities I'm not going into, but there are opportunities. बहुत काफी pluses भी हैं इसमें, जैसे मैम ने अभी बताया भी. Thank you, Akhila. I'll not take much time.
No, thanks, Ashish ji. I think we make note of your points, and we have these kind of questions which are coming in the coming slides. And as ma'am said, the best part is there's a intent to make the changes, as we've seen the 29 central acts which are getting subsumed and becoming 4 codes. It's as old as pre-independence era, and there's an intent to bring them to the it's requirement of the time. If you know that we have the 15 country in the world, amongst the 15 country who brought in the law for gig workers, platform workers, which no one has done it, and the kind of mass the workmen moving into that direction, it's a need of an hour. So going with that, I think let's go to the topical issues. We've tried to cover overall. The first is very important on the interpretation of wages. As you know, the government rationale is to make to bring uniformity, simplification, less ambiguity. With that, the ministry has come out with the definition of wages, which is standard, and it's more inclusive, where we have the components, or maybe the entire CTC, because industry at large use the word CTC. So to start with, it's an inclusive definition, and there are certain exclusions, which are 11 exclusions which are specified, but the exclusions are again capped to 50%. So this is how the definition has been provided, and this is standard to compute all the retirees, whether it's gratuity, bonus, leave encashment. Obviously, for PF and ESIC, there are transition provisions. But when it comes to the PF contribution for the people who are below the cutoff limit of 15,000, the wages will come into the play. So that's where I think, and this has the huge financial implications on the P&L of all the organizations. That's why it's important for us to spend some time here getting views for Dr. Mahendra also. So my first question is to Rashri. Rashri, since we've already touched upon what constitutes wages, I'd like to start by asking, will wage determination under the new framework be carried out on a monthly basis or on annual basis? What's your view?
Yeah. Thanks, Akhil. I think that's an important and a very practical question. So, under the labor codes, wage determination, it is intended to be applied at the time of payment of the wages. And in practice, that will mean it operates on a monthly or a pay period basis. If it's a fortnightly pay period, then on a fortnightly pay period. But at the same time, there are some checks, such as the 50% threshold for capping of the specified exclusions that you mentioned. Now, that may require a periodic review, especially where remuneration structures include, say, variable components or annual entitlements. So, from an employer standpoint, in my view, the emerging approach would therefore be to apply the wage definition on a monthly basis for payment and compliance purposes, while carrying out a periodic or an annual reconciliation, maybe even from a good governance measure, rather than treating wage determination as a purely annual exercise.
Thanks, Ashish, to give a clarity on that. Now I'll go to Dr. Mahendra Kumar. Sir, thanks for patiently hearing us and waiting for we are eagerly waiting for your inputs now. Come on the same wages as formal notification for the EPF, EPS, and ESIC schemes is pending. What will be considered the statutory contribution base for Provident Fund and ESIC during the interim period?
Yes. Thank you. See, though with uniform definition has come in other 4 codes, ESIC threshold is 21,000 as of today, and Provident Fund threshold is 15,000 only. So those employees who are covered under the definition of the employee under Social Security and drawing wages up to 21,000, ESI subscription has to be paid. And those employees who are drawing 15,000 or even above also, so that is not mandatory. Above the wages of 15,000, you have to deduct PF on the part of the employer, but the employee's contribution can be voluntary. So that provision is very clear.
No, thanks, sir. So,
yeah,
yes.
yeah. Just Binaji, I want to add the existing schemes of ESIC and EPF, whatever the contributions are there, 12.5% for both employer and employee, and 3.7 and 0.25 for the ESIC. Those will remain till new scheme is not come up. Okay, that has been given in the code. 1 year time has been given. So these ceiling limits and contributions are same as previous existing one. I think we have clarified.
Yes. No, very well understood, sir. Thank you. Yeah. Sir, one thing
yes.
Related to that, for ESIC coverage, as you know, 21,000 is the limit, and it applies on the gross salary. However, and now obviously it's a transition period. We will come out with much clarity on that. But if the wage is now going forward, I understand that whenever the limits will come. If wages are less than 21,000, but the gross salary is more than 21,000, still we have to follow the earlier provision, and the coverage is not
no. In that case, I just want to clarify. Our codes has implemented from 21st November. Yeah. The definition of wage has come into effect from the 21st November. Yes. And the statutory wage calculation will be done as per existing wage definition. That is in the codes itself. So that is likely that some more workers come in the coverage of ESIC and EPFO due to wage definition. Because in the market, artificial dipping is there. So that is the point. Minaji, you want to add?
Yeah, thank you. So, see, earlier was total emolument. So, yes, I am getting you. So, for example, an employee was getting 40,000 rupees, so he was excluded from the ESIC housing. But as per the new definition, if his allowances are not exceeding 50% and basic DA and retention allowance, all put together is coming to 21,000, then he will get coverage. So that is clear.
So new definition will be applicable now. That
from a coverage perspective, because I remember on 11th of December there was a circular which was taken back on 18th of December, and
yeah.
So from a coverage, I think that's a big input from your side.
That is coming from the code itself. No circular and other things is required. You know, code has come into effect from 21st November, and
yes,
the
sir.
wage definition doesn't require any rule. Wage implementation of wage definition doesn't require any rule, so it came automatically into effect. So you know, gratuity and all these issues are coming higher. This payouts is there on account of gratuity. Provisioning is more. So these things are coming as base definition has been implemented in itself. Yeah.
Got it, sir. Got it. So my next question to you, sir.
Yeah.
Sir, as you know, in the exclusion, the clause E talked about some pay to defray special expenses in the nature of business. So given the open-ended nature of this term, one understanding is that it refers to the cost necessarily incurred in the line of the duty or for the purpose of carrying out the business. Can you please elaborate so that people, accordingly will be able to gauge, what you are trying to say when you say that some pay to defray expenses, because it's an open-ended and people are becoming more creative and getting more components here, and so that they can get the exclusion. So we wanted to have better understanding so that there is no miscommunication or misunderstanding specifically for this clause.
Akhilji, for this issue, we have issued FAQ, that is there with more clarity. But again, I am stating for basic pay, there are three components we know. This basic pay, DRM allowance and retention allowance. That is for the wage.
Inclusion,
now, A to I, we have given the exclusions in these allowances. And in FAQ, we have told the variable pay, that is dependent upon the performance and vary from a person, from a employee to person, that will be the part of remuneration. That we have given here in the FAQ. So that has been clarified, and we have given also ESOP, and these things are not the part of remuneration. So the basic intention of our definition is this artificially lowering of the wages should not happen. That in industry, in many sectors are there. So that is the main motive. Minaji, you
correct. Okay. So thank you, sir. We have discussion earlier also, and through FAQ it has been clarified. And just wait for some time the rules also, so that you will come full clarity. But the wage definition has come into effect from 21st November. That is very clear. So you can give message to the all industry member fraternity that wage definition has been implemented from 21st November.
Okay. If any specific point you want to discuss, we can take up. Any specific on the this allowance issue and this?
Yeah. So that's why I pointed out clause E on the exclusion, which is some pay to special expenses. I think given the open-ended nature of this term,
person to defray special expenses.
And they don't see the purpose of A to I is very clear, sir. Up to 50%, it will not become part of wages.
No, that's everyone is clear.
Correct.
But
right. So
on this E,
these are the expenses, sir. I want to clarify you because these different industry have different practices and different nomenclature.
Yeah,
So
yeah.
these are the languages used, which is not very specific to X or Y. So if it is coming monthly payment in any name, then it will form part of allowances. If it is within 50%, then it is not wages, and if it is exceeding 50%, it will become part of wages. But any payment which is not made regularly monthly, which is annual, or it is related to performance link or any other things, then that will be outside the purview of the remuneration or the wage definition. That is very clear.
No, that's so kind of you, sir. Just one, if I take this example forward, if
Yeah.
a mobile handset is provided to an employee to do the business, that's a requirement of the business. So will that get covered under some pay to defray special expenses? Because that's a one time in a year, or it's a part of the CTC and it's paid to the employee, or monthly mobile recharge. Because in the FAQ which was issued on 30th of December, mobile recharge is treated as a benefit in kind. However, if I go to the rules, the draft rules, central draft rules, there on the definition of wages to arrive at, it's clearly excluded. So should I follow the FAQs or should I follow the rules?
Sir, better we should not much discuss on the draft rules. It is final. It has not reached to the finality. So let us proceed further.
Thank you, sir. Thank you. So my last, before moving to the next topic, my question is to the Sunita. So Sunita, as a member of Quest Corp, one of the largest workforce organization, who's been providing both to the service industry and manufacturing industry at large, how has your journey been since the implementation of the new labor codes? What challenges are you facing in this journey to adapt new definition of wages?
Good evening, everyone, and thank you, Akhil, for having me on this panel, and thank you for the opportunity to be a part of this discussion. Before I begin, I would like to mention that the views that I'm sharing today are in my individual capacity, while drawing largely from my experience, and may not necessarily represent 100% from the official position of my organization. With that note, so at the outset, I would like to acknowledge the significance of the new labor codes, right? They represent a major step towards simplifying and modernizing the India's labor framework. From an industry perspective, the intent is clearly progressive and very well appreciated, right? However, as an organization, transition from policy to practice, right? The real focus now is on implementation at scale. The shift is not just regulatory, it requires rethinking of compensation structures, aligning policies, ensuring consistent compliance across multiple states. So in our experience, the key challenge is not understanding the intent of the code, but ensuring clarity and consistency in interpretation, especially in areas such as wage definition. I think we've been speaking quite a bit about it, worker classification, and of course, alignment with the state level rules. So given the diversity of the workforce and the operating environments, organizations are looking for practical guidance and predictability to implement these changes effectively. So on this note, I also look forward to hearing perspectives from my fellow panelists and sharing some of our on-ground insights as we navigate this transition and the rest of the conversation ahead of the evening.
Thanks, Rita, for your inputs. And as you rightly said, industry at large has taken this as a very, very positive initiative by the ministry. Kudos to the ministry, the kind of hard work, the people sitting in front of us, and there are many people behind the curtain who've done it over the last many months. I've seen that. I've felt that because I have multiple level of discussions with Dr. Mahendra, his team in the past as well. So now moving to the next topic, which is again very, very important, is worker versus employee analysis. I think one of the most critical issues for employers under the labor code is correctly classifying their individuals as workers or employees. Since several compliance obligations now flow from this distinction, I would like Rashri to enlighten the audience on some of the key impact areas before I go to Dr. Mahendra or to Sunita for some questions on this. Over to you, Rashri.
Right. Thanks, Akhil. Right. So, moving on from the definitions to who's a worker, who's an employee, a lot of discussions on this across the industry at large. Now, this is significant because under the Code on Wages, the coverage is broad and it applies to all the employees, including workers. And this is required because it ensures the minimum wages, timely payment of wages, and overtime eligibility where minimum wages are fixed. The distinction comes in because it is more pronounced from the OSH code perspective, where key provisions such as the working hours, overtime, leave, and leave encashment, certain safety and welfare measures, these are expressly linked to the category of classification as workers, which makes this classification critical for an employer. Similarly, in the Industrial Relations Code, it is largely worker centric, which means the governing matters such as standing orders or retrenchment, layoff, closure, grievance redressal mechanism, or say industrial disputes. All of these largely depend on whether the individuals engaged in an organization are qualifying as a worker or as an employee. Therefore, while the codes aim to simplify and unify the labor laws, they also place a much greater emphasis and responsibility on the organization to accurately classify the workforce. Especially, this becomes even more important for certain roles which may be supervisory, managerial, or hybrid roles, wherein it may not be accurately possible to classify an individual as a worker or as an employee. This creates a challenge for the organization in the consistent compliance and to minimize any dispute risk that may come up in future.
Thanks for your analysis and perspective to it. Now, my first question goes to Dr. Mahendra Kumar. Dr. Kumar, I think several obligations under the labor codes hinge on whether an individual is classified as a worker or an employee. From the ministry perspective, how should employers practically approach this classification, particularly in determining supervisory, managerial, or administrative roles, including any wages threshold, and in reconciling the overlap in the definition of worker across different codes to ensure consistent compliance? So I think I break down into three parts. How industry at large determines supervisory, managerial, or administrative roles, any wages threshold in their mind while determining that, and how they will reconcile while the definition of worker across different codes is different, so that there is a consistency in this.
Okay. Akhilji, I hope we have a discussion of this subject earlier also. I want to clarify what Shri has explained is half only. See, the code on wage, I'm coming out with the code wise so that all audience will have clarity on that. Code on wage mandate is very clear. Employee means including your manager and panelists who are sitting before me are employee under the code on wages. So be very clear about that. So I'm not much discussing on that. Minimum wages will be paid for the category of the employees for whom minimum wages have been fixed by the appropriate government. And overtime will also be paid to the employees for whom the minimum wages have been fixed. But wages has to be paid in time on or before 7 to all the employees. So that is the big responsibility given to the employer, and that is the big reform we brought in. So earlier the definition code on wages was payment of wages at threshold was 24,000. So almost 90% of the workforce was not covered. Now that 94% of workforce will be covered under the code on wages, their wages has to be paid timely, including contract labor, daily wages workers, or casual work. So that is the one important aspect has to be taken that as far as the code on wages is concerned. Now coming to the Industrial Relations Code, it is clearly defined worker. Worker means any person who is employed for unskilled, semi-skilled, skilled, technical, or supervisory works, drawing wages up to 18,000 rupees. Again, supervisory and manager function has been agitated before various courts. Those who are learned advocates are there. Even the High Court has held that manager of the branch is a workman because he is not having any administrative or supervisory power. So there are tests laid down by the Honorable Supreme Court. A person who can grant leave or a person who can issue charge sheet or terminate the employee is a supervisor or the manager. So that is there, worker definition. So under the IR code, workers definition for the purpose of worker, there is no wage threshold. Only supervisor wage threshold is there. So that is very clear on that. Now coming to the OSH code. OSH code we have used term worker also and term employee also. I want to clarify all the audience, wherever the benefit is required to be given of such health, welfare and safety facility is to be provided to the employee, but the threshold is for the worker. For example, if you require factory license, if you have 20 and more workers with head of power or 40 and more without head of power workers, then only you will require factory license. Similarly, the contract labor engaging 50 or more labor, then only you will require license, otherwise not required. Section 23 and 24, friends, I want to clarify you. The drinking water, latrine urinals, or the medical facilities required to be provided to the employee, including canteen. But the threshold put is worker. For example, the canteen facilities required by the employer wherever the 100 or more workers are employed, including contracted. Thirdly, we are very clear while drafting the law, the facilities required to be provided under section 23 and 24 is required to be provided by the principal employer as per section 53 of the OSH code. So let us make it very clear when the rules comes in final stage and all, what you are mentioning, the hand holding and also that we have certainly, we are aware about it. That's why we did across countries several workshops and we are engaged almost every week to do that, and are available in future also if you require, we are available to guide you.
Oh, thank you.
Thirdly,
Thank you. Yeah.
right. Thirdly, now coming to the Social Security Code, so there also the term employee is used, and there the threshold is given for the ESIC 10 and more persons, 20 and more employees, gratuity 10 and more employees, maternity benefit 10 and more employees. So as far as definitions are concerned, we have clearly defined it. There should not be only thing is any one person has to read 2-3 times, then we'll have full clarity. Thank you.
Thank you very much, sir. The way you explained, do you have any plans to come out with any illustrative criteria or guidance to help employers make a uniform and defensible classification decisions and reduce disputes during this transition period? Have any FAQs on this as well? Will be expected from the ministry very soon?
See, FAQs are dynamic, so we
I would like to add. I would add to what Mr. Akhil Chandna has said. Under Section 4 of the Industrial Relations Code, there is the requirement to set up the grievance redressal committee.
Right.
You see, now there is a appeal provided if the decision of the GRC is against the employee, but there is nothing provided if the decision of GRC is against the employer. Would you please clarify whether there is any right to appeal or the decision of the GRC would be binding on the employer?
Thank you, Pasin Saab. Very thoroughly you have studied. There is no provision made of the appeal. Only thing is the GRC has to address the grievance of the worker within 30 days. If grievance are still not settled, the demand of the worker or the grievances can be raised in the form of industrial dispute through trade union before the conciliation officer. So, sir, as an employer, you also have a right to form the trade union. So, I need not to write that. So, even sometimes the employer is also having some issues, then certainly you can seek clarification from the conciliation officer.
Thank you, sir.
And in terms of the time,
there is one more clarity which I want to see, that is on the gratuity part, because an employee who has put in, say, 10 years before the code came into force and has continued, you see, with under the new codes with the employer, now his gratuity will be calculated on what basis? Or will it be the last drawn in the new employment, or it will be split into the period of service which he rendered under when the codes were not there, and what was that last drawn salary at that point of time? How will it be calculated, you see?
Okay, thank you. So for the calculation of gratuity, we have not changed any provisions of the existing law, that is Payment of Gratuity Act. The gratuity is payable on the last drawn wages only. So whatever the length of service person has put in before code or after code is immaterial when he is superannuating or if he is resigning, at that point of time, what is the last run wages, the gratuity has to be calculated based on that.
Yeah. So there's we have a clarity. There's no grandfathering which is there, and I think you clarified this in your
Yes,
previous
yes.
conversation.
Correct.
And even in your FAQ. So moving to the next, I'll bring in Sunita here. So Sunita, you heard about how well-defined way in different codes on the worker versus employee classification and all. And as you know that within the labor code provides us with an opportunity to bring more clarity and consistency to roles across the workforce, while terms such as supervisory and managerial are not explicitly defined. This open up space for constructive dialogue and industry-led interpretation. How's the industry, at large approaching this aspect, and what perspective are emerging on this application from industry point of view?
Sure. I think while the code defines worker as any person who is not employed mainly in a managerial or administrative role, or who is employed in the supervisory role with wages not exceeding 18K per month. The law does not yet provide detailed definitions of supervisory or managerial work, nor the thresholds for administrative or managerial roles. This presents a valuable opportunity for further clarity and refinement, according to me. Currently, industry is navigating this open space with care. Employers like us are reviewing classification practices thoughtfully and aligning benefits such as overtime and leave encashment, etc., with employee well-being taken into consideration. While interpretations may differ across sectors, this very diversity highlights the need for clarity, according to me. Right? In this context, how should employers actually approach the review of worker-employee classification under the labor code is a question that runs in my mind. It would really be helpful for the ministry, to share detailed guidelines, ideally with sector-specific examples. I feel to establish uniform interpretations across industries will be greatly helpful, and such guidance will empower employers to implement policy with confidence and also reduce disputes. So this is my perspective on this, and I really look forward to guidance from the department in this regard.
Yeah. Thanks, Sunita. I think Ministry, just before you bring up this question, Ministry has already given categorized code-wise distinction on the worker versus employee, and maybe we are expecting some detailed FAQs. Now, in interest of the time, we have left with 15 minutes, and we have.
But the point here is, just sorry to interrupt. The point here is, if there is an industry-specific classifications, right? Because I think especially this particular classification, I feel it's very traditionally done, more keeping in mind the manufacturing sectors, right? Because there it is the people on the shop floor versus people who are doing the administrative role. So it's very easy to classify in a manufacturing setup. But in a services industries, how could we interpret this better? I think there is still some bit of ambiguity, and I think that needs some bit of ironing out, because this leads to a lot of other policies and practices that also has to be built in, and like I said, we don't want to give room for any disputes. And how do we ring fence ourselves is the point that I was trying to make, Akhil.
Yeah. Perfect. So now I'll move to the next topic again, impact on contractual worker agreements. As you know, which is again a big one. And though we wanted to set up a context, but I think in limitation of time, I'll straight away go to the questions. So my question to Dr. Kumar. Sorry, Dr. Kumar, we have been asking so many questions, but we have so much to learn from you. As you know, under the labor codes, employers are reassessing their contractual workforce models, particularly in the light of the provisions around core and non-core activities and the expanded responsibilities of principal employer. Could you share the ministry guidance on how employers should approach deployment of contract workers in non-core areas, manage transition of long-standing outsourcing arrangement, and ensure compliance with this interim period without disrupting business continuity?
Yeah, actually, this provision regarding core activity that has been taken from Andhra Act state that was in practice from 2004 onwards. We have listed out what are the activities which are not core activities. In definition, we have given. Secondly, we have clarified that in this 57, the ordinarily that one 57, that is 57. Okay. Just a minute.
No worries, sir. Take your time. So meanwhile, if you can, look into the relevant section and provision, we can go to Sunita to check on the industry perspective. Is that okay with you?
Yeah, we can.
Yeah. So Sunita, from an industry and service provider perspective, how are organizations today approaching contractual workforce arrangements under the new labor codes, particularly around deployment in the core areas, non-core areas, restructuring long-standing outsourcing models, while maintaining the business continuity from your side of it? The department will come out how they are looking into it, but from industry, if you can throw some light.
Sure. I think very interesting question. So as per OSH code, Akhil, OSH 2020 code, while there is a general prohibition on employing contract labor or outsourcing activities in core activities, the code has considered the following three specific exceptions where a principal employer is permitted to engage them. Okay. And these scenarios are designed to handle operational fluctuations without compromising the core nature of the establishment, right? One, the ordinarily outsourced scenario, okay, which was followed earlier or which is already currently being followed, right, in the system. This protects the existing business models where specific services, even if core, right, have historically and practically been managed by specialized third-party outsourcing agencies. The second one is the intermittent part-time scenario. If the work is not perennial or it's not continuous, right? If the job only requires someone for 2 hours a day or twice a week, it is not considered viable to mandate a permanent full-time employee, though it is crucial role and the core to the nature of the establishment. Thirdly, the third exception that is there is the sudden volume scenario. So this covers the peak periods, right? The spike given the business demands or special projects. For instance, if a manufacturing unit receives a massive one-time export order that must be shipped in 60 days or similarly, festive season like Christmas for retail industry, so they can augment their workforce, core workforce, with contract labor to meet that deadline. So this is the perspective that I have, and then what I have been observing from a very close quadrant.
Thanks for input. Really important. Sir, we come back to you from how you guide industry at large on the approach while development of contract workers in the core, non-core areas and manage the transition of long-standing outsourcing arrangements without disrupting the business continuity. Dr. Mahendra Kumar, I think you're on mute.
Yeah. Basically, we have simplified this process. Earlier, this tripartite board and other things, tripartite board was there. So this issue was more complex. Now, this is single designated authority will see which is core and non-core if some dispute comes. So that is I think, big relief in this matter. And at the same time, as Madam also clarified, these three conditions covers many issues. So it will, I think there will be no issue on this further. So that's my take in this. Minali, you want?
Yeah. See, in the central sphere, there were so many activities, PSU specific, where the tripartite board was there and they have recommended and government has prohibited certain employments. So the tripartite board having representative from representative employers, union and government, and then they study and then giving it. So this method I will make very simple. Now there will be one designated authority. If any question comes, then only you have to approach to the authority, not that you have to go prior to any dispute for approval of authority. No, don't misunderstood that. So you clarify to the all industries, whatever is going on continuously will continue. That protection is given under Section 57. And if at all any question comes or any union is raising an issue, then this authority will be the competent person who will give the decision, and that decision will be final. So there need not to be any worry about that. Rather, we have make it the process very simple, so that industry should not have a much burden on that, whether I should engage contract labor or not. So we have tried to clarify it, because before defining and all, we have a detailed consultation with the employers representative also. At least 8 meetings at national level I have attended and I have clarified it, and we have detailed discussions with the advocates of the employers organization also.
Understood, sir.
Right.
No, thank you for throwing some light. I think we left with 3 minutes, but if you don't mind, we can continue, because there are a lot of other issues which needs to be touched upon. We can extend this webinar by 10 minutes.
Quickly do it. 5 minutes.
Yeah. I think the other point I want to touch upon is overtime, and wanted to understand, as your employers are seeking clarity on eligibility calculation and alignment with existing practices. And my question to you, sir, again coming back to you, while the labor codes lay down a clear framework for overtime, employers are facing practical challenges around its implementation, particularly on who is eligible. The first question comes: who is eligible for overtime, the wage base on which it should be calculated, and how to reconcile code provisions with continuing shops and establishment laws. These are the three big questions where we need your guidance. If you can throw some light, sir. Eligibility, wage base, and
I got your question, sir. It is not first time it has come. We are hearing it in industry almost now and then. So we are aware about it. See, overtime is regulated by 2 laws. The establishment which is not covered under OSH is covered under the Code on Wages. So Section 14 is very clear about the overtime. The overtime is required to the employees for whom minimum wages have been fixed. Okay, that is very clear. Wage definition is the same what we have already discussed. I will not go into much discuss on that. OSH Code Section 27, 28, 25, 26, 27 deals with the overtime provisions. There we have to frame the rules, and rules have not yet come. But I want to clarify you there. OSH Code provides provision for the overtime to the worker only. So that you have to bear in mind. Whosoever is covered under the definition of worker, he is only eligible for the overtime wages. It is normal the wages double the rate, and wage definition is already there. So that is there. 8 hours is written in the code itself. That 8 hours will be the working hours of a worker in the establishment. So further details will come in the rules. So let us wait for that.
Okay. So thanks for giving that clarity. That rules will throw more lights and clarity on that, and we will wait for that. Thank you. Now my next point is leave encashment, and I will quickly ask Rashri to, before I take up the question, to quickly outline the leave and encashment related provisions under the code so that we can give some kind of clarity to the audience at large.
Right. So very broadly, it is the OSH code, which is the primary legislation governing the leave and leave encashment for workers. In terms of entitlement, workers are entitled for 1 day of leave for every 20 days of work performed in the preceding calendar year. This provision broadly aligns with the earlier factory-based legislation, but it is now embedded within a consolidated OSH code, which applies to all the sectors. In terms of the carry forward related provisions, the unavailed leave may be carried forward, subject to a ceiling which is prescribed in the rules. It would be 30 days, which is currently prescribed, but this would also depend on the state rules or any changes that may come up in that. Another side of the leave or leave related rules is the corresponding legislation from the Shops and Establishment Act perspective. So currently, we are seeing that employers have to look at both the OSH code applicability and the leave provisions under the state Shops and Establishment Act as well. So that is where the navigation is currently, a challenge for the employers.
Thanks, Rashi. So again, my question to Dr. Kumar. I think obviously, as Rashi said, under OSH code, it clearly sets out leave and leave encashment entitlement for the workers, and how much can be carried forward. Obviously, the state rules will come right now in the central 30 days is a prescribed. But so the industry at large is a bit confused right now because shops and establishment, if you ask me, in NCR gives the 45 days as a carry forward window, and in central it's 30 days. So what pace they should opt under the new code, under the new labor codes, and what should be the appropriate wage base? We understand the wages which are defined as uniform should be taken, but right now the industry is encashing the leave only at the time of exit, and that too on the gross salary. So I just want to understand from your rationale and substance why this provision was brought in the first instance and how the industry should look into it.
Okay. See, first about the leave encashment at the time of resigning or superannuation. So, wage definition is very clear. So, whatever the component coming in the wage, you have to calculate the leave encashment according to the wage definition.
Understood.
With regard to the carry forward, yes, rightly you have mentioned the rules are not yet to come, final rules. So let us wait for that. But we have the flexibility in that. If any company is having better pro-employees provision, that can continue because threshold is given 30 days in the code, but that can be depend on the rules also and the company regulations also. And that is again the sector wise it is there. For example, working journalists and sales promotion employees, that threshold is higher than that. So that is there. And rules, there will be more clarity on that. But the leave encashment has to be given on the definition of wages, which has come into effect on 21st November. Those who are retired and their encashment last settlement has to be done as per the new definition.
One more thing I want to add. We have issued FAQ on this, and in respect to comparison with Soap and Establishment Act, the beneficial provision will prevail. This is a beneficial provision will prevail.
No, thank you, sir. Thank you. That brings clarity. And sir, one more thing on the leave encashment. As we know, earlier the leave encashment happens only at the time of exit, whether it's a superannuation or resignation for that matter. But now, beyond 30 days, if the leaves are lapsing, the employee has a right to ask for the encashment year-on-year basis. Is this a right interpretation to take, sir?
The subject to the finalization of rules.
Okay.
For example, employee is having in his credit leave 30 plus 10 days.
Yeah.
This example I am giving. And he has applied, but you have not sanctioned the leave. Then he is entitled for the encashment of his leave.
Okay. Got it. Understood, sir.
You got it? Right.
It's fine. For my last topic, which is again a big one on the gig and platform workers. And I need, both from you and Sunita, a perspective there. Sunita, from an industry and aggregator perspective, how are companies and platform implementing the gig and platform workers provisions under the labor codes, particularly around compliance, readiness, contribution mechanism, and engagement models, while the regulatory framework is still evolving? What trends or shifts are you seeing? How organizations are preparing for this change?
Sure. Let me respond this in two parts. One, from an industry and an aggregator lens, it's important to appreciate that the new labor codes mark a dynamic shift by clearly defining and covering gig and platform workers, including the domestic workforce, within a formal legal framework. So this inclusion is a landmark step towards social security. In terms of implementation, we are seeing progress on two parallel tracks. One, the system readiness. Most organizations are already equipped with the systems required for tracking gig work engagement and managing their business models. The infrastructure for audits and workforce classification is largely in place. On the operational evolution, however, the landscape remains in a prepare now, adopt later phase regarding statutory payments and welfare fund contributions. At the same time, platforms are piloting voluntary welfare initiatives such as accident insurance, health cover, and transparent pay statements while engaging with worker associations to strengthen the trust. While the systems are ready to track, the specific financial mechanics, contribution rates are still evolving, including the central code versus the state level codes are in the draft form for notification. So once there is full regulatory clarity on these welfare mandates, we expect a final wave of transition and transformation. That's how I look at it. And organizations will need to move beyond simple tracking to a full operating model redesign, shifting from what does the law require to how do we build a scalable, sustainable ecosystem for this strategic workforce segment.
Understood. I think thanks for your detailed, understanding and giving the perspective. Now, my last question to Dr. Kumar before we conclude this session on the gig and platform worker. Sir, with the states like Karnataka already operationalizing this framework through specific notifications, we want you to share your perspective on how central level schemes and state level initiatives are expected to align, particularly to avoid overlap or duplication for that matter, and your guidance on how you offer, would you offer to platform and employees as they navigate contribution mechanism, compliance expectation, and transition timelines in this evolving landscape?
Actually, we are working on this rules, and that is in advanced stage, and same with schemes. Social security scheme for gig and platform and organized sector worker scheme. So we are working and that are in the advanced stage. So that is our stand, and I think you will shortly see these things. Yeah, that is connected. Rules, schemes are connected.
Fine, sir. Thank you for your time, for your guidance, and patiently taking all the questions. Though we have more than 100 questions in the chat box, obviously we will answer them separately. And the way the passionately you, Vandana ma'am, everyone has taken this initiative forward. I would like to thank you on behalf of our Indo-American Chamber of Commerce for coming for more than 1.5 hours during this peak time of so many things happening. And I will request Dr. Lalit Bhasin or Ms. Ashish, who is still on the call, to thanks all our prominent speaker experts for their time and taking this initiative. Dr. Lalit, over to you.
Yeah. Many thanks, firstly, to you, Akhil, for really moderating this webinar exceedingly well and highlighting the issues you see which the industry and the professionals they are facing in the implementation of the codes, and yet to be finalize the rules, because part of the codes have become operative because they are not connected with the rules, and rules are yet to be given a final shape. So given that scenario, the views expressed by the learned secretary, Madam Vandana Gurnani, and Dr. Mahendra Kumarji and his colleagues, they are very, very productive, useful, and they are very valuable inputs. They give some clarity. And also my gratitude to Sunita and Rajshri Sarna and all others, who have made this webinar possible. I think we need to meet again after about month and a half or 2 months when the rules are in place, so that the issues can then be crystallized and then debated upon again. So thanks to all of you. Thank you.
Thank you, sir. Thank you. Thanks, everyone. And you will be glad to know that more than 1,000 people joined today. And stay with us till last question, 700 people. So everyone was very keen to hear you. And as Dr. Lalit Bhasin said, that we should do the series of this webinar to bring more clarity and showcase the efforts which the ministry is making to align it and get this implemented at the root level, whether is MNCs or small, medium enterprises and all. And I will, before we conclude, the man behind everything is Ashish Vidji. He's with us now. Sir, your last words of before we conclude the session. I don't know. Yes, sir. Ashish ji, we're not able to hear you again if you're talking something.
No, he's in the car.
Yeah. Thank you, everyone. Thank you.
He's the moving spirit, so I think that's all right.
Thank you for the discussion, Akhil. Thanks for everyone for setting it up. It's been very insightful.
Thanks, Sunita. Thanks. Bye.
Bye.
Thank you so much.